Hi, hello everyone. Welcome back to Clat Possible YouTube channel. Uh, Feb current affairs first part we have done already. Today we are going to look at the current legal affairs from the month of February itself. But the second part is here. That is from the second half of the February month, right? So जनवरी का करंट लीगल अफेयर्स ऑलरेडी यूट्यूब पर है. गो एंड वॉच इट अगर आपने नहीं देखा है ऑलरेडी. फेब का फर्स्ट पार्ट भी है. दिस इज फेब सेकंड पार्ट, राइट? सो वी विल ओनली डिस्कस the most relevant and most anticipated topics from this part, and it starts from the suicide pact. So recently there was this news about suicide pact. सुप्रीम कोर्ट ने बोला था कि सुसाइड पैक्ट एंड अबेटमेंट में क्या रिलेशन है. सो जो रूलिंग थी दैट वाज दैट अ सर्वाइविंग पार्टनर इन अ सुसाइड पैक्ट कैन बी हेल्ड गिल्टी फॉर अबेटमेंट ऑफ सुसाइड. तो बेसिकली बात क्या चल रही है दैट लेट्स से देयर आर टू पीपल who have a suicide pact, in the sense that they have an agreement, they decided to commit suicide, right? So one of them dies and the other one survives. Okay, so what is the liability of the person who has survived is the question. Of course, when B has died, there is no liability for B, but A has survived. So what is the first thing is that whether suicide attempt in India is punishable at all as a crime. So the answer is yes, it can be made punishable. It depends on the purpose of suicide attempt. So if the attempt of suicide is out of depression or distress or some kind of trouble, then it is not punishable. But if attempt to commit suicide is through an agreement or used as a pressure tactic or some other unlawful means, unlawful purpose, तो फिर ऐसा सुसाइड अटेम्प्ट जो होता है दैट इज पनिशेबल. ओके, सो इन दिस केस इफ दे हैव एन अग्रीमेंट, इफ दे हैव अ पैक्ट टू कमिट सुसाइड, then A can be liable. Now the question is that it says mutual commitment to die together provides the necessary psychological impetus for suicide. How is it an abatement? The entire question is that if two people decide to commit suicide, how is it abatement by one to another? So clearly there is this psychological motivation, there is this moral support available, and that's why because the moral support is available, the psychological connection is available, it becomes a case of abatement. Okay, and यहाँ पर participation क्या होता है? This is intentional encouragement and facilitation. So the fact that one person has intentionally provided some sort of encouragement or motivation, that in itself becomes the reason for abatement. ठीक है, थोड़ा सा और आगे चल के देखते हैं कोर्ट ने क्या बोला है. इसके अलावा जो रेलेवेंट प्रोविजन है अबेटमेंट ऑफ सुसाइड का, ये आपके लिए इंपॉर्टेंट है. यहाँ से पैसेज बन सकता है. You can also expect legal GK question from this part. Okay, section 306 of IPC gives punishment and the definition about this. Any person who abets, right? And abatement का मतलब क्या है? Some sort of encouragement or it could be some sort of help. ठीक है, आगे जाके देखेंगे अबेटमेंट के जो रियल मीनिंग्स होते हैं काफी सारे होते हैं, बट फॉर नाउ जस्ट अंडरस्टैंड दैट प्रोवाइडिंग सम सॉर्ट ऑफ एनकरेजमेंट और हेल्प इज अबेटमेंट. Okay, and that section is 306 of IPC. Now in 107 of IPC, what constitutes abatement is very very important for CLAT, I would say. देखो CLAT में इसके ऊपर डेफिनेटली पैसेज मिल सकता है because it is an important part of the criminal law, right? So first thing is that instigation. Okay, if A instigates another to commit a crime, to do something wrong, then it can be classified as an abatement, right? So clearly जो provocation है, to provoke somebody or encouraging the act, उसको हम बोलते हैं instigation. Instigation always have some sort of provocation. Okay, then there is conspiracy, that is a simple agreement with or without provocation. Sometimes it happens that two people decide to commit a crime and they may not have encouraged each other, they may not have instigated each other, but they still, if they conspire to commit a crime, if they have agreed to commit a crime, that in itself can also be referred to be a case of abatement, right? then providing some sort of assistance. Intentional aid refers to some sort of assistance or help, I would say, which could be physical, psychological, in facilitation of the act. Okay, so it is not confined to physical acts. Mental encouragement is also sufficient. For instance, if A tells B, his friend, that he wants to kill C, his rival, A's rival, and B simply says that, whatever you do, I'm with you, right? So that is also a moral support that B has provided to A, even though nothing in physical terms, nothing in physicality has been provided to him, no help in physical terms is provided, but still this case will amount to a case of abetment. I hope I'm clear on this part. Let's quickly proceed to the next one. एंटीसिपेटरी बेल के ऊपर सुप्रीम कोर्ट ने क्या बोला है रिसेंटली अबाउट एंटीसिपेटरी बेल? ओके, लेट्स सी. फॉर एंटीसिपेटरी बेल, ऑलरेडी मैं बता चुका हूँ लास्ट सेशन में कि एंटीसिपेटरी बेल क्या होती है. एडवांस बेल होती है व्हेन अ पर्सन इज एप्रीहेंडिंग अरेस्ट. ओके, जब उसको लगता है कि वो अरेस्ट होने वाला है, हो सकता है, तो वो पहले ही एक बेल सिक्योर करके रखता है, बेल का ऑर्डर अपने पास लेकर रखता है. जस्ट इन केस द पुलिस कम एंड अरेस्ट हिम और ट्राई टू अरेस्ट हिम, he can show that order and get released. I mean, he will not be arrested in the first place, right? Now, court ने बोला है कि can refusal to hand over a personal mobile phone be treated as non-cooperation justifying denial of anticipatory bail? मतलब ये हुआ है कि a person has been arrested and during the investigation he was asked to hand over his mobile phone, to which he refused probably, and on this ground he was denied anticipatory bail. You know that you have not cooperated with the police or with the investigation, that so that is why you are being denied the anticipatory bail. So is the denial correct, legally correct, is the question. Sorry. So for that we have Article 20 Clause 3, which says that there is a right against self-incrimination, which means no forcible evidence by a person against himself. No forcible evidence by a person against himself, right? So this person को arrest किया है या जिस person के against investigation चल रहा है, उसी से forcibly extract नहीं कर सकते evidence जो उसके against use होने वाला है. So in short, it's related to confession, that a person cannot be forced to confess. Okay, so basically अगर वो मोबाइल फोन अपना हैंड ओवर करेगा, so that is going to be equal to giving evidence against himself. Am I correct? Because that mobile phone may contain information or data which will be sufficient probably, or which will help the police to crack the case, which will help the police to build a case against the accused, right? So ये इसके लेकिन this is a right of the accused that he cannot be forced to give evidence against himself. Now see, the provision for anticipatory bail is, which is also known as advance bail, which is granted to a person even before the arrest. Okay, so it depends on what is the crime, the nature of the offense, what the accused has done, what is the need of the accused in the interrogation, do you need him or not during the interrogation, or how much he is going to cooperate with the investigation or the agencies. So it's a combined understanding. It's a combined ground on which anticipatory bail may be given or may be denied. Right now, this is about NDPS Act. So this case belongs to the NDPS Act. The question is that does cooperation with investigation include surrendering potentially incriminating personal devices? तो क्या मतलब हुआ potentially incriminating का मतलब something that will leak or disclose information against oneself. Incriminating का मतलब होता है information that discloses commission of a crime. तो फाइनली सुप्रीम कोर्ट ने बोला कि कॉर्पोरेशन के नॉट ओवरराइड आर्टिकल 20 क्लॉज 3, जिसके अंदर ये प्रोटेक्शन मिला हुआ है दैट फोर्सिबल एविडेंस एक्सट्रैक्ट नहीं कर सकते। ठीक है, दूसरा है स्टेट कैन नॉट कंपेल सेल्फ इंक्रिमिनेशन अंडर द गाइज ऑफ इन्वेस्टिगेशन, ऑलरेडी एक्सप्लेन्ड। So yes, that's the conclusion that was held, that if a person does not want to cooperate with the investigation, तो इसका मतलब he is actually protected under Article 20 Clause 3, and that cannot be a ground for denial of anticipatory bail. Although I am personally not convinced with this judgment, because Article 23 is not, does not cover a situation like that. Normally a person is can legally be forced to deliver his mobile phone or laptop or things like that. So that we will study when we do Article 20 properly. I will tell you in detail that in what areas Article 20 is applicable, in what areas it is not applicable. But ठीक है, अभी जो कोर्ट ने जजमेंट बोला है हम उसको समझ लेते हैं. That should be more than enough for us. Next judgment we have is about pay and recover principle. I want you to first read this and then we will discuss what is happening here. तो सुप्रीम कोर्ट का पे एंड रिकवर प्रिंसिपल है. क्या होता है पे एंड रिकवर? क्वेश्चन इज, कैन एन इंश्योरेंस कंपनी बी डायरेक्टेड टू पे कॉम्पनसेशन? दिस इज द फर्स्ट थिंग. First and recover later when a person dies while traveling in a goods vehicle. The vehicle is a goods carrier, even if the insurer is technically not liable. So the question is that, let us say there is a goods carrier which is, let's say, a truck or a tempo which is expected to, which is meant for the purpose of carrying goods, right? Not human beings or not people. So if there is an accident, if there is a mishappening with the goods vehicle, and there was a human being also traveling in the goods vehicle, so what is the liability of the insurance company, right? तो ऐसे समझते हैं that let's say the insurance company has an agreement with Mr. X for the insurance of his vehicle which is a truck, and जो कंपनी है उसने क्लियरली बोला था कि it's a goods vehicle, so only goods must be carried. You cannot carry any person, you cannot carry any passengers in the truck. But despite the policy, Mr. X was found carrying people along with goods, right? Now insurance company had only assured or has had only taken up liability with respect to goods, any damage to the goods, but they've not taken any liability with respect to persons or human beings. So the question is that when there is a human being carried in a goods vehicle, suffers an injury out of an accident, whether the insurance company is liable to pay compensation to that person also who is traveling in a goods vehicle. So he is basically an unauthorized occupant of the goods vehicle. So obviously the logic clearly says that no, why should he be liable? Because the policy was limited to insurance of goods. But then that's what the principle says, pay and recover. That means even if the insurance company is technically, legally, logically not liable, okay, even if the insurance company is technically, legally, and logically not liable, they will still have to first pay the compensation to that victim, and then later on they can recover that money from the owner or whatever. This is called pay and recover. So at that moment when the accident has arisen, when the victim has suffered injuries, when he needs the money, at that moment the insurance company cannot deny the payment. Later on they can of course recover it as a matter of right. This is what the judgment is all about. I want you to read this, all of these points, then I'll explain once again. Yes. So, like I said, the deceased was traveling in a tempo, had to carry a Ganesh idol for immersion. Now, Ganesh ji की जो मूर्ति है, that is classified as goods, ठीक है, and tempo, then it may be called a goods carrier, okay, or a goods vehicle. Now, उसके अंदर डेथ होती है, पर्सन डाइड, व्हीकल वाज अ गुड्स व्हीकल इंश्योर्ड विद ओरिएंटल इंश्योरेंस, लेकिन ऑर्डर क्या आया, पे द कॉम्पनसेशन फर्स्ट, that's the first step, right? And then you can recover it from the vehicle owner. Always remember that whenever there is a car or there is a vehicle which is not insured by any insurance company, then the owner of that vehicle is liable to pay compensation in case anything goes wrong, if there is any mishappening, anybody suffers an injury, death occurs, whatever. So the owner of the vehicle shall be liable if there is no insurance of the vehicle, right? So the tribunal had previously given an order that was set aside by the High Court, which has been set aside by the Supreme Court, and finally the Supreme Court has just supported the view of the tribunal. Okay, what tribunal is relevant here? It's called MACT, which is Motor Accident Claim Tribunal. Motor Accident Claims Tribunal. It's called MACT, which is responsible for deciding cases that have arisen out of motor accident. Okay, so we are clear on this part. Any doubts if you have, let me know. This is the legal finding. Vehicle hired to carry goods, right? And what is the dominant purpose test? It simply means that the dominant purpose means what is the main purpose of the vehicle, or what was being dominantly done, or what was being primarily done. So the question is that whether goods were being carried primarily or human beings were carried primarily. Okay, if human beings had been, if human beings were carried primarily, then if accident had happened, I am sure no compensation would have been given. Okay, for example, in a tempo which is supposed to carry goods, 20-30 people are being carried. Okay, then it meets with an accident and people die, some get injured. I am sure the court would have said that no, in this case, the insurance company is not liable to pay compensation because primarily, dominantly, the vehicle is being used for human travel. Okay, but in this case, the vehicle was used primarily for carrying goods, right? And the human occupancy or human connection to this vehicle is only incidental. It is only incidental. So incidental also means only we can say secondary, not primary for sure. We can say secondary. तो जो डिसीज था, जो पर्सन मर गया था, उसको ट्रीट किया गया एज अ ग्रेशियस पैसेंजर ट्रेवलिंग विद हिज गुड्स होल्डिंग. नाउ व्हाट इज द मीनिंग ऑफ ग्रेशियस पैसेंजर? So gracious passenger refers to a passenger who is not the primary occupant, but he is there, to facilitate something, to provide help with something, to assist in something. That's what is called gracious passenger. Also refers to a passenger who is traveling. Who is not traveling as a passenger, right? But only as a service provider or as a facilitator. So I hope now it is clear that what is the meaning of pay and recover later liability. It is a very common form of liability in insurance claims, in motor accident claims, and you can definitely expect a passage from here, even a legal GK question, that what does the principle really mean. Okay, if you have any questions, let me know. Otherwise, we proceed. So I told you the relevant law is the Motor Vehicles Act. Yeah, the MV Act, which is 1988. Gracious passenger कौन होता है? Without hire or reward, मतलब he is not getting any payment or any money to travel in that vehicle, and he is also not covered by the insurance policy. Very, very important, because the insurance policy is primarily covering the goods only, right? So everything is just the same. There is a repetition of legal provisions, there is a repetition of facts. I don't think you need more explanation on this. Okay, this is a simple principle. Yes, dominant purpose test I've already explained to you. If the primary purpose is carriage of goods, travel is incidental, then pay and recover can be ordered. Great. Now, one legal issue in the beginning we had skipped, which is important and we need to do it now, is about POXO. In POXO law, what is currently the Supreme Court said that attempt versus preparation, what is the distinction in sexual offenses? I mean, how do we identify specifically with respect to sexual offenses that at what stage attempt to commit a crime is committed and at what stage preparation to commit a crime is crossed? Okay. So if you know the basics of criminal law, there are 4 stages of any crime. First is mens rea, and second is preparation, third is attempt, and fourth is commission, right? But normally these 2 stages are not punishable. If a person only has mens rea but no and only has done preparation to commit a crime, it is not punishable. Becomes punishable only when he has performed something which is an attempt to commit a crime and to successfully committing a crime. If there is an attempt to commit a crime, or if there is success in committing the crime, then only it is punishable. So that's what the court said, that this was a very controversial judgment that had come up, that whether holding a minor girl's breast, losing her pajama, sting and attempting to drag her constitutes attempt or not. तो पहले जो एक कोर्ट था उसने, आई मीन इलाहाबाद हाई कोर्ट जो था, दे सेड दैट नो, it will not amount to attempt. It was a very controversial judgment. They said it will not amount to attempt. They said that the intention of the accused cannot be made clear. I mean there is enough time available to withdraw from the act. All of that logic was given by the Allahabad High Court, but then the Supreme Court did not agree with that. So it has restored the summons under section 376 of IPC, which is about rape, and the section 18 of POXO Act, which is about sexual assault on minors, right? तो कोर्ट ने इसमें बहुत इंपॉर्टेंट फाइंडिंग ऑब्जर्व किया है कि the only intervention by third persons prevented completion of the offense. So होता क्या है कि when does an act become attempt to commit a crime, right? मतलब सक्सेसफुल कमीशन और अटेम्प्ट के बीच में क्या डिफरेंस है, क्या होना चाहिए? तो लॉ ये कहता है कि इफ समथिंग हैज बीन डन फॉर द पर्पस ऑफ कमिटिंग द क्राइम, राइट, एंड इफ यू वर नॉट प्रिवेंटेड या फिर if no obstacle came in your way, then you would have performed that act. For example, if A is holding a gun towards B, right, and if he wants to shoot B, so if he has fired a shot, okay, that's attempt. The moment he fires a gunshot, it is attempt, because after that, if you don't prevent him, he will, the bullet will hit Mr. B and injure him or probably kill him. ठीक है? तो अगर to do something which would succeed if not interrupted, in simple terms, what is attempt? To do something which would succeed if not interrupted. That's an attempt, and at that stage, criminal liability can be imposed. Okay. Now, going by that logic, the court said that grabbing a minor's breast, loosening her pajama would be a sign of attempt, because if not prevented, he would have ended up committing the assault. He would have ended up committing the rape. ठीक है? ये वाला पॉइंट बहुत इंपॉर्टेंट है. इंटरप्शन और फेल्योर डज नॉट नेगेट अटेम्प्ट. अगर इंटरप्शन हो गया है तो अटेम्प्ट तो फिर भी हुआ ही है. आई टोल्ड यू, राइट? फिर से समझ समझ सकते हैं. A has done something, if not interrupted, it is attempt, like firing a gunshot. Okay, giving somebody poisoned food article, if not prevented, it would end up committing the crime. So this is the judgment from the Supreme Court, and they've also given a definition of attempt, like begins when intention is translated into direct execution. तो इसका एक और मतलब होता है clear indication of the intent. Clear indication of the intent. अगर किसी का clear intent दिख जाता है तो उसको attempt बोल सकते हैं as per the Supreme Court. I hope I'm clear on this. Things are absolutely clear. Any doubt, let me know. Well, this is the section 18 of POCSO Act, which is in dispute. So let's have a look at this also. I want you to first read this. Okay, so anybody who attempts to commit any offense under the POCSO Act या फिर कोई भी अटेम्प्ट करता है तो उसको पनिशमेंट मिलेगा इम्प्रिजनमेंट का, जो कि मैक्सिमम हो सकता है 1/2 ऑफ द पनिशमेंट प्रिस्क्राइब्ड फॉर द ऑफेंस. 1/2, दिस इज द मैक्सिमम पनिशमेंट फॉर अटेम्प्ट. ओके, सो फॉर एग्जांपल लेट अस से सेक्सुअल असॉल्ट जो क्राइम है, लेट अस से उसकी पनिशमेंट है 6 साल. फॉर एग्जांपल सेक्सुअल असॉल्ट की पनिशमेंट अगर 6 साल है तो सेक्सुअल असॉल्ट के अटेम्प्ट को करने के लिए कितने साल की सजा होगी? 1/2, that is 3 years, right? Okay, for attempt only. Attempt is when you don't succeed. When you do succeed in committing the crime or in attaining the object, then you are punished for with the full length punishment. All right, clear है? Complete offense का complete होना जरूरी नहीं है, तभी अटेम्प्ट होता है. और क्रिमिनल लॉ का बेसिक प्रिंसिपल मैंने एक्सप्लेन किया ही था. मेन जरिया ओवर टैक्स सफिशिएंट होता है, थर्ड पार्टी इंटरवेंशन से लाइबिलिटी कम नहीं होती है. ठीक है, या so these are the applications in child sexual offenses. Any sort of physical restraint, sexual touching, removal of clothing, or dragging a child with sexual intent can amount to attempt. It is a very important piece of legal information for all of us. The Supreme Court has clarified that what all can amount to attempt in sexual cases or in POCSO matters particularly. ठीक है. Proximity, what should the courts examine? Proximity, that is how close to the object or the aim. How close to the object or to the aim. That means in order to become successful in committing the crime, how close has the accused gone? If he is far away from succeeding in the crime, then it is not attempt. But if he is close by, if he is sufficiently proximate to the goal, then yes, he can be held liable for attempt to the crime. All right, so that is it. This we already have done about the Suicide Pact. So these are the most relevant legal principles which are recently held in the Supreme Court or discussed by the courts. And so with this we have done majorly, we have done all the relevant parts of current legal affairs from the month of February. There are some topics that I have not covered in this, which are huge topics which would need a separate session or a separate video for that matter. So I will come up with those sessions independently, separately, over and above these sessions. Don't worry, with topic specific sessions will be there. Okay, so do wait for it. And if you have not subscribed the channel so far, please do it right now, because you have seen that a lot of important relevant content is getting uploaded here every day. You are going to be benefited immensely with the video series. Keep studying hard, keep reading law, keep understanding the legal interpretations of the law, focus on the letter of law, and become a good reader, right? Ultimately, that's the test. That is the test on which CLAT will differentiate, or select people, right? So if you're a good reader in general, you definitely have an edge over others. Okay. Uh, Abhi, I'll sign off for now, and then I'll come back after some time with another topic, with another power packed session only for you. Bye bye. Thank you. Take care. All the best.